Good afternoon, everybody. I see not everyone that registered has joined us yet, but I think for the people that's on time, I think we will start so that we don't take up too much of your time, because your time is just as valuable as mine and everyone else's. So I want to introduce you to Namisha. Namisha, I'm not going to try and say your surname. I
That's
haven't
fine,
heard it, and I
Rupert.
think I'm going to have a tongue twisting experience. So, Namisha works in compliance in Pretoria. She will tell you a little bit more about it. I actually got to know her a lot better in 2018 when we had to do compliance monitoring around the drought in the Western Cape. Um, but we have met afterwards and a couple of times, even after I left the department. The latest that we met was at the Danish embassy, and we had a nice chat afterwards. So I know Namisha is passionate about her work, and she would really like to share it with us. And she's hoping to get some good feedback from you guys. So, Namisha, over to you.
Okay, thank you, Nicolette. Good afternoon, everyone. My name is Namisha Muthraparsad. I am from the Department of Water and Sanitation National Office in Pretoria, and I come from the regulation branch representing compliance monitoring. I deal specifically with industries and agro processing. So anything to do with power generation or green industries, anything that is FMCG, down to hydropower, down to the coal-powered, and all the agro processing sites as well, such as feedlots, maybe um, abattoirs, all those type of things I deal with in terms of compliance monitoring. We are known as the Blue Scorpions, and I'm also an alumni of Danida. So my presentation today involves a whole lot of learning that we have in terms of partnerships with the industries, partnerships with scientific bodies, as well as general learning from what we do, what we call compliance audits. So I'm going to switch my video off, but it's just for the bandwidth issues. And any questions will be at the end, which Nicolette is controlling, and you can feel free to also ask questions in the chat that we will pick up at the end. We have about 45 minutes. I think I am under 30 minutes with my presentation, but it is titled Partnerships Between Regulation, which is us as government, Science, which is you as the scientific community, and Industry for Improved Water Use. So my contents, just to take you through, I'll introduce you to what we call governance. So how do I, as an official of the Department of Water and Sanitation, what are my rights and what is it that I do? So my governance structures, the playing field specifically for water, the regulatory framework and cycle, water use entitlements, or what we mean by that, engagement and what we have learned from industries. What is the playing field for partnerships? This is something new which we've coined as part of my studies. And communication lessons. Why do we need to talk more? Why do we need to engage more? And when we did do this with industry, what did we find versus a stalemate of what we could see where we are usually seen as opposing sides to each other? I'll also bring in a little bit of a case study with conclusion. So my case study, I'd like us, any thoughts or critiques that you have, because I related it directly to groundwater. It's because we need to have more conversations on this to see whether we need updated regulatory frameworks. And from there, I think we can then be able to best advise industry as to how they should work. So the reason for my presentation and where we've been looking into is, number one, is approaches to regulation can be confusing for industry or even for the general public if they don't fully understand water use. And industries always indicate them to be hurdles to economic performance. Monitoring requirements are defined as being costly and timeous and can lead to an attitude of inaction. This is especially true for water use compliance monitoring because there's also an out of sight, out of mind sort of attitude that we see a lot. But it's also because certain impacts, when they are cumulative, cannot be seen immediately. And therefore, if I don't see it, then I don't need to act. It can lead to a lack of generation of vital monitoring information. I am speaking to the monitoring community, but what we know is that I cannot manage what I don't monitor. That is what we believe in industries and compliance monitoring. For me to make better water use decisions in terms of water security, insecurity, and water pollution, I need to be able to have some sort of system that is generating good monitoring data that is on a continuous basis in a changing climate. For us as government, where we can learn is that we would be able to provide a better service, a better public service by developing our skills and understanding industries. There are so many industries and sub-industries and subsectors in the country that sometimes it can get a bit overwhelming when you want to understand the process. One subsector of industry itself can have many different processes that they employ. There's no two industries, even in the same subsector, that are the same. Our understanding and scientific skills, we can have better organizational, internal organizational adaptation, and we can be a better public service. So our partnership between the regulated community, which is what we call the water user or the industry in this case, and us as the regulator, because I monitor water use, I am a regulator, it often uses the terms called the carrot and stick approach. And what that simply means is that the stick approach is that these are the rules. If you do not follow them, there will be consequences. The carrot approach can be seen more as what is it that I need to do to get you to a state of compliance, but I do it more from a less of a stick approach, maybe at a incentive approach. But an incentive approach has to be clearly defined so that we make sure that our goals are of water use are met in the environment. I'm saying that because a lot of times we write things on paper, and what we say in paper and what happens at operations in the field and in the water is two different things. And that's why we have to be very clear on what is the carrot that we are using it. It may not promote water resource damage in any way. Another inherent problem that arises when we effect regulation is that must be done in a timeous manner for environmental protection. And there are differing opinions between business, governance, and the scientific fields. They do not always meet in time for environmental protection efforts. One of the things we can see that in is our current setup, there are many instances where we need to be able to act in time, but business needs to act, and according to the rules that I set, my rules need to be clear. But if I want to have science-based decision making, my science also needs to be clear into what is it that we are going to be using it for. So just an overall view of governance structures as to where we input or we use as part of compliance promotion. The next 4 or 5 slides is directly what we engage with industries when we do compliance promotion. So as water and sanitation, we don't work alone. We work between national, provincial, and local government. And that implies there must be a lot of conversation. And we also work with environmental affairs, mineral resources, energy, agriculture, forestry and fisheries, municipalities, utilities, amongst others. In terms of the way regulation is set up, legislation is set nationally, and we have the National Water Act, which helps us and also sets rules for how we may engage and make legislation. We have policies and strategies in terms of those legislation, which is set by national. Regulations can be set in national or provincial, and then there's bylaws which are at the local level. However, none of this may be in conflict with national legislation. So when we want to say what is the playing field and why we are here, this image is indicating a playing field, and we have related it to water. So what is a playing field for if I'm speaking to an industry? The playing field is a free space for reaching a goal, a standard, or complying with regulation. In our case, how much of water you use, how you treat that water, what are you doing with the water resources, and what are you doing with your effluent or wastewater management. Within that space, you can do whatever you want or need to do as long as you stay within those lines. And the ball in this case is how you need to be able to handle it. And we will teach you how to give you those skills. Is we set rules, we give you official guideline documents, or it can be online. We have dialogue and spoken guidance from authorities, which is ourselves, and we have help from experts, which is yourself. That's what we call the science-based decision making in terms of water resource management. So what helps us is regulation and communication has to come into this field so that we can better play the game. So how do we understand it in a South African context? The image on the left is there was an argument about what is clear boundaries. In that match, we lost, and we lost a World Cup. And it was very clear over there how the conversation carried on and is still carrying on as to where was the boundary. The recent rugby match, which we won, we had a whole conversation that is still going on about what is the interpretation of the law. So what happened here? Was it lawful? Did he have control of that ball? That's where this comes in. But the playing field for water is why we set the rules. So to reduce in the cases below, the sporting cases, there's a lot of conflict, there's a lot of miscommunication. The boundaries are being reset, people are being confused. So to reduce that, we need to, with industries, understand where the playing field is. So the first start of where we come from is Section 24 of the Constitution. Everyone has the right to the environment that is not harmful to their health or well-being, and to have the environment protected for the benefit of present and future generations through reasonable legislative and other measures. We then had a white paper on national water policy, enabling us for equitable access and optimum resource use and protection. And finally, we have the National Water Act, where our main purpose, which is very important, the sentence, the nation's water resources are protected, used, developed, conserved, managed, and controlled for sustainable and equitable use. We indicate this to industries is that our job is not to take away your water. We provide you with water so that there can be socio-economic development, but you must stay within the rules for sustainable and equitable use. So the regulatory cycle starts with authorization. Someone would apply and then a license would be given to them. I would then come in for an industry and do compliance monitoring on that. And I also don't just follow National Water Act, I follow the PAJA cycle and or Administrative Justice Act, where I must make sure that I communicate clearly and bring the water user or the industry into compliance first. If they do not respond to that, I then go to enforcement. This, of course, does not apply to unlawful activities. Unlawful activities are straight illegal, and they will go for enforcement action and for correction and rehabilitation. The types of water use entitlements, some of you may be familiar with. Schedule 1, generally seen as very low risk. But what we found when we read through and look at the implementation of the Act, it also acts through or implies water use through municipalities. So if I have a major industry using that water, I'm unable to audit them based on the fact that they sit in a municipality. I therefore ask the municipality to ensure that they are meeting the rules. And the municipality will be creating the rules for that. And earlier on, I indicated that is why their rules have to follow our rules at national as well. We have existing lawful use, and any lawful use of water authorized by or under any law before and during the period 1st October 1996 to 30th September 1998. This is prior to the 1998 National Water Act and was governed by the 1956 Water Act, but it was only for taking of water, storing of water, and for Section 21 of discharge of water. There are new uses under Section 21 of the current National Water Act. And in terms of governance, we see a large number of especially agro-processing sites that are governed by ELU, which I will address later. We have general authorizations for much smaller operations and can be seen as lower risk. And these apply to certain limits, conditions, and areas, but you must meet those limits. Does not mean that in any case, even though they're regarded as lower risk, that you may change from what is published. We then have Section 22.3, which you can only dispense with the requirement if satisfied that purpose of National Water Act will be met by another piece of legislation and authority. And then we have our main one, which is licensing, our much bigger operations. And these are for higher risk activities and bringing, if a water user has many different entitlements, we also use the licensing process to bring them under one document to make it administratively clearer. And they are also subject to certain conditions, and very important in this case, especially since National Water Act 1998, is that all licenses or all authorizations must have an expiry period. And this is one of the basic differences between the 1956 Act and the new National Water Act, because there were certain wastewater permits that were given that did not expire. And that means that certain conditions are not updated to the latest best practice guidelines for wastewater management. So Section 21, many of you will probably be familiar with it, so I won't go through in detail. But basically, we have water for abstracting. When you take it from a water resource, either ground or surface water, you then store that water. Section 21D is for generally afforestation, commercial afforestation activities, because the growth of these reduce the stream flow to the stream itself. And C and I generally go together. It's impeding or diverting the flow of the water, or anything that you do to the habitat of the water course. So altering the bed's bank course or characteristics of that water course. We then get to the discharge related, which is where we have some discrepancies on the understanding of waste and wastewater. And that is Section 21G, engaging in a controlled activity. So this could be aquifer recharge with whatever wastewater you have. In one of the most common ones is irrigating with slurry wastewater or manure wastewater onto land, which will be in direct contact with groundwater through seepage. We have Section 21F, discharging directly into that resource, and then disposing and storing wastewater, which may detrimentally impact. So where you see a pollution control dam or a wastewater storage dam, that would be Section 21G. We have groundwater monitoring cases there. Section 21H is similar to Section 21F, but now it is heated. If it is heated, then we then effect Section 21H. J is when an industry could you could have a high groundwater table operations, or there's a safety issue, they will remove and discharge and dispose of that water. But again, we will set water quality limits there. And we also have to ensure that the aquifer is not impeded in any way. Section 21K is for recreational purposes. At this stage, we don't have major authorizations that we monitor in this case. So in terms of engagement and the purpose of this presentation, why do we do it? Number one is engagement implies communication to understand the playing field. So when we get to the playing field, I need to make sure that a client understands water use and environmental impact. When you understand water use, I then need to make sure that you understand it in terms of governance and why I ask the questions that I do, why I check what I do, why I take actions that I do if I go to court. The scientific or technical know-how that designs a process for water use and how it interacts in governance is vital, because this is where there is nothing that can be done in an industrial operation that does not have some sort of scientific or technical knowledge. And when this is done, when there are changes, which is very common in industrial operations, we need to understand whether someone is still in their governance rules or not. That can change. There could have been a good intention, but they may go out of their governance rules. That is why governance or government also needs to engage continuously with what is the updated technologies. So how a water cycle works in an industrial operation is extremely important, and is what we concentrate on when we audit a site, because we need to make sure that that water is not treated or contacts anything that could be added on and that is not in the limits that may be specified. One of the new things that we are seeing is you see the PFAS, or they call them the new and emerging pollutants. If I have a license from 20 years ago, not likely to have that. So we need to make sure when we are on site, we need to understand what happens to that water and each and everything that it contacts with, because I need to be able in the wastewater to be trace all those elements and chemicals back. Stakeholder analysis is very important, and these are one of the things that we learned, or I've learned from the Danida courses, the water sector governance, and we had to do a stakeholder analysis, and you understand all the different voices coming in, you understand how to classify them and put them in a hierarchy, and it really helps with implementation and moving conversation forward. So that's one of the main things of preventing a stalemate in engagements, is that you must move the conversation forward, you must implement, and stakeholder analysis helps a lot because it helps you understand each other's point of view and it helps you set goals for implementation. So the playing field now for partnerships is what I see it as, is that I cannot work alone. I cannot just set rules on paper. The main impact is in the field or in the water. How does this work? So as government, I need to engage with science. Science needs to engage with me. Business and science need to engage with other. Business and government need to engage with other. And the whole point of this is to make sure that we have efficient, resilient relationships and we have better conversations, because new issues can crop up and governance needs to keep track of that, needs to keep up to that. But business as well also needs to keep track of impacts. So climate change is a typical example of what happens. I now have such water variability that sometimes it gets difficult to predict. I need to know where my water resources are. One of the most important things is water resource mapping, knowing where it is in the landscape. If you don't understand that, we've seen one of the biggest problems when we get to site, and how to make sure we are getting industries to comply and making sure that they are meeting their current water governance or water best practice guidelines with regards to water use. A typical example of the olden days and existing lawful use is that wetlands were not seen as very valuable. But a lot of people then damaged, or if you look at land use plans, they will find that they will remove wetlands because it's seen as not beneficial. And either they're going to do some sort of process on it, they're going to allow the animals and livestock to roam in these. And then although it destroys and affects my characteristics of that, my wetland watercourse, but National Water Act, they are protected. But now I need to change the mindset, and certain rules under the olden acts allowed these. And I have to be, as government, take cognizance of this and find new ways and how I can improve with it. That is why we have to continuously have a compliance promotion conversation on understanding water resources. So in our engagements, there are certain things that we learned, and maybe it might help you as well. Engagements is that we always have stalemates or people on opposing sides of the law or opposing sides of the conversation as well. And we don't seem to get anywhere. Our point is to implement, is to better water use. We know we have damaged water resources. We need to improve. We are not saying that they cannot ever be rehabilitated. Our goal is to rehabilitate and get ourselves to a point of resilience. And when you communicate, one of the things that you must be is consideration. So you must have balanced understanding of each other, where you are coming from. If you understand each other as part of your first steps, you can then do dual goal setting. And you can therefore agree on dual implementation as well. Our main point is implementation. Otherwise, if we don't understand each other, we will continuously have a conversation, and that can go on for years. When we have consider each other, we have then an open conversation. We must be able to have a continuous cycle of questioning, but also taking decisions. Else, again, as I said, we will talk forever. And then monitoring for effectiveness. What is my main goal? If I'm on a site, what happened? This site is from the 1940s. I have massive groundwater plumes. What is it that I want to do? Do I only want to talk about how this plume is advancing? What happens when the site closes down? I need to be taking decisions and planning for these decisions and make sure that I'm always monitoring and generating data so that I can better manage these sites. Because I am continuously changing my processes and my thinking, I need to be able to do change management. This is one of the biggest lessons we've learned from the Danida courses as well, is that there's always going to be change if you want adaptation or to resilience. Each person can redefine what resilience is. That's what I've personally learned, is that everybody redefines. Even a water resource, they can redefine it to suit them. But you must be able to change the way someone acts, and you do that by changing how they think and accept, but it has to be mutual as well. You won't always meet. It has to be completely cyclical where you continuously talk to each other and continuously make each other understand. But the only way to approach resilience is you have to change and adapt, and you have to see each other's point of view for you to take that decision to adapt and to reduce time constraints. The reason for this is we want to reduce ambiguity, we want to reduce anomalies, and we want to reduce non-compliance. So findings from industry engagements, I do understand that I am speaking to the scientific community. I do not have a lot of pictures because this is a lot about partnerships. So we are still generating all that information, maybe in a future talk. But what we find, which actually was surprising, is that many industries are open to conversing in water usage, and they definitely show interest in understanding how water is governed, because they do have environmental, social, and governance goals set. Business operations are time constrained and need clear and concise guidance. So one of the things I found when we are on site as water officials, I would say something like, "Why didn't you do this?" And the person would say, "No, I understood it from this point of view." So they are receptive to newer regulations because they are time constrained. They are concerned with producing that product. And of course, they are a business, they will make a profit. We need as government also to make sure that we are clear and concise in what we want and what we say. And then of course they also want to understand what is the resource and cost requirements to them. In any conversation, I would advise you is that when you are saying what you want, is always put in the resource and cost requirements, because that is the basis of any business operation. And once they know that and they know return on investment, they will be able to engage with you better on what their limitations are. Certain limitations exist for product quality and health considerations in reuse cycles. So reduce, reuse, recycle is the biggest thing that we have in going forward for moving water conservation. But there are certain things that as government we have to understand when processes change as well, that they cannot do simply for in terms of health and safety or for product quality. So we need to have a conversation again, what is it that we want to do? And this is especially where scientific communities come in on creating new procedures on what we do with these. So scientific advancements can change water requirements and can change governance thereof. And updated best practices, we found improve planning for water. So writing a document and leaving it and not attending to it for many years won't work anymore. Guidance on water governance, or what we call compliance promotion, in relation to scientific principles, because I want to do scientific-based decision making, it's really stimulates the conversation of why water resources must be protected. A mutual understanding of environmental requirements and the business needs opens communication. This is one of the biggest things by understanding their point of view, asking them of their process, because they are very proud of their processes and achievements as well. It really does open up the communication and improves understanding. And it can even lead to uptake of new methods. I've had a lot of times where I've imposed or requirement in the industry, and they'll just say, "I cannot do it in this operational budget. I have to do it next year. Give me the time by when you need." And that's currently the conversation we're currently having, is to say, how is it I can do this without affecting my quality of my water resource? So when you lead to uptake of new methods, that is of course improving adaptation and to changing environmental, climatic, and economic situations. So my case study that I bring to you is that this is currently where a partnership is active with myself as compliance monitoring industries and an industry partner. And one of the water use that we are in contention with is Section 21E, engaging in a controlled activity. In this case, it's irrigation with wastewater from their animal husbandry operations. It's an agro-processing industry. Sorry, the slurry from the animal husbandry is used for field application as manure. This is a very familiar thing in South Africa. We also have guidelines. One of those are from 1978. So wastewater limits exist with groundwater monitoring, and that is from National Water Act 1998, because that is where Section 21E was first recognized as a water use. So in licenses or general authorizations, I have a whole lot of mitigation measures. Prior to 1998, there may be existing lawful use in these agro-processing sites. And no limits or monitoring requirements have been set. So in terms of governance, I've already got a problem for those because I have, there's no legal concept or document that is saying you must do this by when. I need to look at my processes and see how I need to manage and develop if it's new regulations for that. So in this case, what the science is saying, the scientist that we are dealing with says manure improves soil nutrient value and the water quality limits that you have set are too stringent. Industry has said I need the limits relaxed as per the scientific interpretation to improve my operations and compliance, because each time if it's too stringent, he cannot make it, I mark him as non-compliant and it affects his business reputation. As government, I am saying limits that are set are standard applications. So for all types of agro-processing sites and for all types dealing with irrigation with wastewater. And these were scientifically informed for water protection, but we do recognize that slurry waste is defined as biodegradable waste. This has led us to a stalemate where our conversation wasn't going and we were continuously on opposing sides. So what we did is now in terms of the conversation, we formalized our conversation and we agreed to work with an agreement. We've called a memorandum of agreement. We said in a certain timeline, we have goals and a defined timeline for implementation as to how I'm going to improve water usage. One of the main things was definition and understanding the process. So for government, what I've done is that I increased my site audits to increase understanding, and I increased the questioning on the site for every single aspect, not simply what I was seeing or on site. I wanted to know the process at every single stage so that I could understand what they were coming from. We indicated that water use monitoring is for monitoring sustainable use of water and not for affecting a business's operations. So at the beginning, I said, what was the purpose of the act? Many businesses believe we are there to take away their water. That is not true. And that actually helps in opening up the conversation and them explaining to us what is it that we want to do. And it does reduce the tension quite a bit as well. We found that government was referring to measures for water protection. Industry was referring to improved land capability for continuous operations. That is why they said nutrient increasing of the nutrient value. But when I was looking at the limits, all I saw was groundwater protection limits. I saw river protection limits from runoff and stormwater. And they did not see it that way because they said it improves the soil microbiome, you have increased carbon storage, and you have a much more productive land. And what helped getting us to this conversation was continuously questioning that helped me find the motivation behind the interpretations. But this is very important when it comes to the governance and definition. So the resolution is that from this case is that we are still continuing because our agreement is active for the next 5 years. We're going to increase understanding from both sides, and it's still ongoing, and I don't have a solution for this yet because it needs a much wider conversation, especially a scientific conversation of what is acceptable. Data generation via monitoring is key. That will be key. That's what we've said. We said we should not be making decisions without any type of monitoring and having trend line analysis where I can make a decision. But both parties have to consider this. One, climate change, water security impacts, and the main point here is definition and interpretation of what is water pollution. I said going beyond those limits is pollution. The industry and the scientist is saying that no, it is not. It is all that nutrients, all that comes from the slurry gets used up by the microbiome in the soil, and we've got soil. We've had productive soil being generated. It has a very serious regulatory impact for when it comes to a definition, because I do not want to create a loophole or a gap or have some sort of gap where there is going to be pollution of groundwater and it has been set as regulatory where I've relaxed these limits. So that is why I've also brought this as a case study, because one of the main things in this case study is groundwater and amelioration of any pollutants going through. I know in theory, and I know from case studies that groundwater treatment is extremely expensive, and it's also not something that we should be doing. We should be protecting it at high cost. But what is acceptable? So if I come in as a regulator and say I do not accept this, then the scientific community here in this case comes back and says, but I found this. So where is acceptable, what is not? And that is why the conversation has to go wider than our little task group in this study or with this industry. And any comments that you have, I am hoping that you are more than free willing to share for it. But in terms of conclusions in this, or you're welcome to give any suggestions or guide me to any protocols or documents. But what we found in conclusion is that although government regulatory protocols are seen as a hindrance, they actually are a very necessary change management tool to adapt mindsets for sustainable water use. Government processes can serve as the supporting foundation. Current project that we have with industries is that we are developing the water balance calculators and water conservation guidelines for them, which reduces the cost on them. And you are more than welcome to contact me regarding that as well. We are currently piloting sites, but this relates back to the carrot and the stick approach. What is it that I can do to assist you in getting to water conservation? And we found that on site, I want to know about water balance. I want to know about water conservation. Industry would come back and say, okay, you want that. What is it that I do? Then it left too much of ambiguity in what needed to be done. So we said, let us make us as government be a supporting foundation. Let us create this for you and you test it on site for your use. And of course, your industrial data belongs to you. I am interested in how it relates into my water use, into my impacts for water security and water pollution. We also phrase the conversation to say that water and business operational resilience are codependent factors for socioeconomic progress. A lot of times, people would even tell us that it's just a paper exercise. It is literally not. I think from the drought, we've seen this. And we always make sure now in the past maybe 2 to 3 years is that we always bring the water and business operational resilience together. Otherwise, they are on opposing sides. Regulatory tools must use the best available knowledge and have a supporting structure as part of implementation. And definitions will play a vital role in this because that is the basis of a regulatory case is definitions and what can be said in court and what can't be said in court. So regulatory bodies must engage with industry to understand hurdles to implementation. For example, they may need a 3-month delay. And feedback and review loops allows for adaptation over time, but it has to be continuous. Once you stop the conversation, even after a year, everybody simply just gets lost and goes back to olden ways. And the only way to get to resilience is change, is adaptation, and then therefore change management. And for that, we are saying that conversation is conservation, and that's how we feel that going forward, how these partnerships would work. You cannot move forward in water conservation if you do not talk to each other. And that's all from me. Thank you.
Much, Namisha. There's one question in the chat that I'm going to share with you. It's from Peter Olshausen. He says, we recently initiated a water sharing research project for the WRC to ensure our strategy and recommendations align with legislation and that our interpretations are correct. Who are the DWS person as key stakeholder that we can contact?
Okay, for regulation, I think if I could just unpack what is water sharing research? Is it between industries? It's transfer of water between industries?
Johan, maybe if you want more information.
Yeah. Okay, I think while he logs in, I can share that what we've done with WRC as well, we have an agreement where we meet regularly at least once a quarter, so that any research that WRC is doing, that the department is involved to ensure that we can implement it in some form. So the reason for that is, and I serve for the regulation branch. So if perhaps maybe if you give me the research project number through the groundwater division, mine water sharing with surrounding. Okay, I think if you give me that and then I will provide it. We do have a section here that deals with it, which is water resource regulation. It's also under compliance monitoring. It might be that they are linked to that project. And we, of course, the reason why we have this agreement with WRC is to ensure that we are implementing best practice, but the best practice is for water. So we don't want projects to be created and they are not implemented because they do not meet the National Water Act and National Water Resource Strategy. So I think if you give your project name and I think it's the reference number that comes with it, the project number, and then I will add it to that list and we will send it out to the interested party. We do have someone who deals with monitoring. I personally deal with the industries, and my other colleague, Abashoni Nefale, deals with the agricultural sector. So we do meet regularly on that. I would appreciate if you did that.
Okay. Peter, please contact Namisha about that. And then there's a question from Fulani. Fulani works for City of Cape Town. He says, from adaptive management perspective, how often is the compliance monitoring reports information used in resource assessment or resource status assessments? And is the partnership looking at this aspect?
The current reports, yes, this partnership that I have specifically is for an agro-processing sector. So it's with the association and their members. So one of the main things with the partnership is that either of our processes must not interfere with each other. So if I have an enforcement protocol running, my agreement may not interfere with that because the law is bigger than the partnership. But what we do is we've increased our compliance promotion and what is it that we want. So we are becoming very clear and concise in what is it that we want and what they don't understand. When there is a non-compliance, we continue with our processes from the department, but we are also indicating at the association, but because we're from the regulatory branch, we cannot indicate, of course, the names of the individuals involved because it's in the regulatory cycle. But we do indicate to say this is wrong or this is right or this is appreciated. So in that way, that adaptive management perspective, this is how we are using our memorandum of agreement. And it is the point of the memorandum of agreement in any case to do this. So in terms of resource status assessments, are you talking about water availability or water quality?
Pelani, you want to ask the question? Give more clarity?
Sorry, can you hear me?
Yes.
Yes.
Perfect. So it's regarding water quality and quantity. And the decisions that are made from a water use authorization perspective as well. I mean, that's where I'm actually going with the question. Thanks.
Okay, so thanks, Plani. The department has another section that does the reserves and sets the resource quality objectives. So those resource quality objectives are set. They are scientifically set as well. So all the compliance information that we get and the limits set in authorizations are based on those resource quality objectives. The moment they are non-compliant, it means they are not meeting my resource quality objectives, and that is why I've marked them as non-compliant. And I must make sure either the pollution stops or that I get you or that I have to take you to court if you are in any way contributing or doing an unlawful activity. So the issue that comes with information that continuously is being generated is that our governance documents cannot change sort of on a daily basis. But the way the resource quality objectives are set is that they can be reviewed every 5 years. If there's a contestation of that, then it has to be a proper legal route of how that is done, and then we follow that process. But once that is signed, we believe that it is scientifically informed, and all those resource quality objectives information goes into the licenses. So it is already accommodated with every water user because the license is never given without consideration of resource quality objectives. If there are errors, then the Act allows us to have interpretation of these, or to have these conversations of where we can amend these licenses or even make stricter rules or stricter regulations. Happened to in this past 5 years, for example, let's say this has happened to the Berg River, I am now setting these rules or restrictions in place until improvement. So the Act allows me to do that. That's how we adapt the regulation. But it has to be evidence-based, because we will be challenged in court. And everything in court has to be about evidence. Okay. I hope I've answered your question. Or do you need our Western Cape contact details as well if you wish to engage with them further?
I think you might have met the people from Western Cape, Fulani.
Sorry, through you, Chair. Look, I'm not necessarily personalizing it from the City of Cape Town perspective, but I'm just looking at it broadly, and I think we've missed a boat here in terms of from an adaptive management perspective, in terms of utilizing the information that is sort of mandated to be provided as part of the license conditions, and making use of that information for decision making in terms of conducting those resource status assessment, and even adapting or changing the resource quality objectives that have been put in place. So I think maybe my recommendation maybe for this particular project that you are working on is maybe look at that aspect as well, in terms of how can we be more efficient in terms of utilizing those compliance monitoring information in assisting us better manage the resource, but also make better decisions moving forward. I mean, you could have given a license to a specific user, but then upon reflection, you realize that, hang on, man, this is it's not going in the direction that we are. The resource is not in a good state. So we should be able to change our minds in the face of new evidence. Is what I'm trying to say, and utilizing all of the compliance reports in a specific catchment to make those decisions. Yes, thanks.
Yes, okay. For that, we do what we call trend line analysis per water user and for the catchment. So yes, it does affect you. We are affecting, the Act also allows me to take away and suspend a license. So that we've dealt with a couple of those cases as well. That is correct. And then the enforcement cycle involves arrest and criminal prosecution. So yes, the Act does allow me to do that. We don't simply do the reports and not and have like a perpetual cycle of discussion to say I will comply. It doesn't work like that. We are tightening that up. You will find that we, in our reports that we publish as well, we've started in the past 5 years publishing the names of companies and their performance. So that is one of the ways we are trying to push compliance to make sure that we get them as close to 100% or A+ as possible.
Thanks, Fulani, for that. I agree with you. We should make better use of the information that you guys supply, not just you, but other license holders, to compliance in our management cycles and decisions. It's one of the things that I also saw as a gap when I was at the department. Namisha, just for interest's sake, Fulani used to be at the department as well.
Okay. Just another disclaimer for data generation. Remember, there's a whole lot of laws that protect data. So when data comes to the department as part of regulatory relationship, I simply cannot go giving that out because it can be misused. And I can be taken to court with that. That is why our job in compliance monitoring is also to improve our skills of interpretation of that data. What is compliance? What does it mean? What is my impact? But not just increasing that. I think I emphasize taking action. What am I taking action on? And taking action is the one where we consider what is your previous compliance status, even for continuation of a license. That can affect you, yes.
There was a hand up earlier, but I don't see it anymore. Is there any other questions that you guys would like to ask?
Nicolette, can I perhaps ask a question?
Razan, go ahead.
Good afternoon. So I'm always, something that sometimes catches me out is water quality compliance. And sometimes it doesn't seem where it'll say if it seems like the license doesn't always take into account seasonal variation of water quality or basically the natural state of the water. And it'll say water, the parameters need to stay within this, but the parameters it mentions might not even be like if they say the EC shouldn't exceed 120, but it might be in an area where the natural salinity is around 200. So then it's difficult to do that, and sometimes it doesn't always take into account. So if it's a site where they use chemicals, then the compliance monitoring will still only include the basic parameters, but where there's other contaminants that are actually quite serious. So it's more just how does that to set a license to write the conditions for compliance monitoring. How does that go about? Because it doesn't seem to always take into account things like seasonal variation or the specific contaminants on site. To me, as a consultant, would note these are the contaminants that you need to monitor, but then that's not reflected within the license.
Okay, thanks for that, Diesel. Two parts to this question where you speak of the natural state of water. And that speaks a lot to assimilative capacity of the river. And that is a very contentious issue even I think of the water resource, because it means my primary function in the water resource, or my primary rule that I'm employing, is that I'm relying on a water resource to ameliorate and to take away and dilute that. And
Namisha, just a clarification. Groundwater naturally sometimes have a 200 EC.
Yes, no, I'm getting to that.
Okay.
I'm getting to that. But I'm saying what happens in terms of governance is that sometimes there's a law of general application in terms of what we want to do and what understanding is. So when we have been doing these limits and the primary focus is on using dilution potential or assimilative capacity, we are not finding that it's working very well in that. So the seasonal variation, I think a lot of the old licenses as well, you will find they did not consider these seasonal variations. But what we have done from our side is that we have licensing which continuously looks at these in relation to the RQOs. That's why the RQOs are updated. So it's a continuous conversation, because what is acceptable to some is not acceptable to another. It depends. Sometimes the conversation comes from an operational point of view, as you're saying, is that why do I have to do this EC if in winter time I'm not, the seasonal variation, the EC is much higher. So that goes then to the second part of the question is, was the baseline information provided correct? Because you will find that not a lot of times that the limits that are set are those that are provided for that. If it has been missed in the license itself, that can be seen as one of those anomalies, which we do when we go on compliance site, then we will correct it and we can amend it from there. So the National Water Act allows me to amend and add limits in, but it is something that we picked up where, example, let's say a site could have chromium and it's not one of the basic ones. So we've increased our requirements for what is it per your site, especially for industrial, because so many different industries use so many different chemicals and it speciates in so many different ways. So we make sure that we try and get a comprehensive analysis on the chemical makeup of those products or the site, so that when we write the conditions, all of those are in there, because as I said, especially with emerging pollutants, it is one of those gaps that we are seeing. But in terms of how we can do it in terms of the Act, we can amend the water use license for that. So have I answered both your questions? So there's seasonal variation and the natural state of water. We, coming back to the baseline conditions, the baseline monitoring is proving to be one of the main things that we need to be doing. There's a problem with that, in that baseline conditions over time have changed and we do not know the original, the no-go one. So when I'm seeing a river at a river state of a D, we've got industries that are saying that that is the state of the water, you cannot charge me beyond that. And in certain ways, they may be correct, but a river operating at a D is not an ideal condition. I want to get it to an ecological status of at least a C or a B, because my point is water protection. So before 1998, dealing with the legal frameworks, a lot of emphasis was put on using water for production. We did not consider the reserve. We did not consider water protection in totality. And we did not consider the protection of the habitat of the reserve. So for me to say that, okay, the natural variation is this, we actually relook at those conversations, because my point is to improve. It's not to say that this is strictly the baseline. I need to follow the limit according to that, because I don't think then I'd get or improve from either F, E, or D to a C or B, where I want my water resources resilient, because I don't want them just functioning to take pollution away. I want them to be resilient as well. But we are looking into that, Lizanne. So if the water user sees that problem as well, they can come to us for amendments. We do that on a frequent basis in case, but of course it then goes to a reinterpretation of what is acceptable and what is not. Okay, thanks.
Okay. Questions that you want to ask before we close off? Doesn't look like it. Namisha, thank you very much for your presentation. Nice soon. Thank you guys for attending. Thank you, Namisha.
Okay, thank you, everyone.